Hello, this is Judicial, Professor of International Relations in Abat Oliba University in Barcelona, and together with my colleague, Professor Maria Mancaldi, we are going to present the analysis, the study, Judicial Authority Without Compulsion, the International Court of Justice between Consent, Power, and Contemporary Geopolitics. In the present moment, in these times of reconfiguration of international order, in these times of crisis of international institutions born after the Second World War, we are facing as well the crisis and the lack of capacity sometimes of the International Court of Justice to implement, to enforce the rulings, the decisions. As you know very well, the International Court of Justice is founded in 1945, more precisely on 24th of October 1945. It means at the beginning of the new world order after the Second World War. The International Court serves as the cornerstone of United Nations judicial framework, proposing peaceful resolutions to disputes between states and interpreting and enforcing international public law. This court is the guardian of global peace by providing a platform for legal adjudication among nations. The court plays a crucial role in the international peace by promoting to add to the legal norms and principles. But nowadays, the court is facing significant hurdles, including a lack of power to enforce its rulings and the necessity for states to consent, and this is a key point, the necessity for states to consent the court's jurisdiction, leading to questions about its authority. For this analysis, we are facing the following methodology. We will present a comparative legal and analytical framework, evaluates the International Court formal mandate against its practical constraints, using case studies to illustrate how authority operates under a structural and geopolitical pressures, and more than ever with the present frame of several wars and brutal realism in front of international liberal order. The Central Research in Cairo assesses how far the International Court can function as an impartial and legitimacy generating institutions in a fragmented and power asymmetric international order. We present different analytical dimensions. First, consensual jurisdiction concept, weak enforcements, Security Council dependence, politicized judicial elections in the members, and representational asymmetrics, and the exclusions of non-state actors in this new world where non-state actor could be extremely relevant and even more powerful than some state actors. And we integrate geopolitical lens, legal reasoning is evaluated alongside geopolitical contestations to capture the core performative and not coercitive authority.
Now let's talk about the structural, procedural, and political constraints of the International Court. One of the biggest structural limits of the ICJ is that it does not have automatic jurisdiction. States must consent to the court's authority. This consent can be given in advance for a specific case or even withdrawn entirely. Because of this, states can simply avoid the court if they choose to. We can see this in several cases. In Cameroon versus Nigeria, the court ruled on a territorial dispute over the oil-rich Bakassi Peninsula. The ICJ decided that the sovereignty belonged to Cameroon. However, Nigeria initially rejected the ruling due to domestic opposition. They eventually complied after negotiations and international pressure, including mediation by the UN. This shows that the court can work, but only when states are politically willing to accept the decision of the court. Similarly, in the Anglo-Iranian oil company case, the United Kingdom challenged Iran's nationalization of the oil industry. The ICJ Well, in this case, Iran argued that the court had no jurisdiction because it has not consented to this type of dispute. The ICJ agreed that it lacked jurisdiction, meaning that the case could not proceed at all, highlighting how states can block the court from acting. Similarly, in the Aegean Sea continental shelf case, Greece tried to bring Turkey before the court over disputes about seabed resources in the Aegean Sea. Turkey refused to recognize the court's jurisdiction, arguing that there was no valid legal basis for this case. As a result, the ICJ could not move forward. These examples highlight a key issue. The ICJ authority depends on voluntary acceptance, not legal obligation. Now let's talk about lack of enforcement mechanisms. Even when the ICJ issues a judgment, it has no direct power to enforce it. There is no international police force or enforcement body attached to the court. This creates a gap between legal rulings and actual compliance. For example, in the Corfu Channel case, British warships were damaged by mines in the Albanian waters. The ICJ found that Albania was responsible. However, Albania refused to pay for many years, and the UK only received compensation decades later through indirect means. In the nuclear test case, Australia and New Zealand challenged France's atmospheric nuclear testing in the Pacific due to environmental concerns. France refused to participate fully in the proceedings and continued testing. Although France later announced it would stop atmospheric testings, it did so on its own terms, rather as direct compliance with the court. And finally, in the diplomatic and consular staff in Tehran case, Iran was held responsible for the seizure of the US embassy and detention of diplomats. The ICJ ordered Iran to release the hostages, but Iran did not comply. And the crisis was eventually resolved through political negotiations rather than the court's rulings. Now let's talk about the dependence on the Security Council. If a state refuses to comply, enforcement can theoretically go through the UN Security Council. However, this introduces a major political limitation. The Security Council has 5 permanent members with veto power. As we know, the United States, Russia, China, France, and the United Kingdom. This means that enforcement depends on the political will of these countries. A clear example is the Nicaragua versus United States case. Nicaragua accused the United States of supporting rebel groups uh, mining at its harbors. The ICJ ruled that the US had violated international law in order to cease its actions and pay reparations. However, the United States rejected the ruling and used its veto power in the Security Council to block any enforcement action. Now let's talk about the politicization and exclusion area. The ICJ is also influenced by politics in its internal structure. Judges are elected by both the UN General Assembly and the Security Council. While legal qualifications are important, political alliances often play a role in who gets selected, which can raise concerns about neutrality. Additionally, only states are allowed to bring cases before the courts. This excludes individuals, NGOs, and corporations. This is increasingly problematic because non-state actors play a major role in areas like human rights, environmental law, and global governance. Their exclusion can make the ICJ seem less relevant in today's international system. Finally, let's talk about representation asymmetries. The ICJ bench does not fully reflect global diversity, and there are imbalances in both gender and regional representation. This can create the perception that international law reflects the views of more powerful regions. Improving diversity will strengthen the court by increasing legitimacy, incorporating different legal traditions, and building greater trust. In conclusion, the ICJ plays a crucial but limited role in international law. It serves both as a legal authority that interprets international law and as a diplomatic actor operating within political boundaries and realities. The main limitations include its reliance on state consent, its lack of enforcement power, and the influence of political powers. Ultimately, the ICJ authority does not come from force, but from legitimacy and persuasion. Thank you very much for your attention.
Thank you.
A ver, voy a dejar de grabar.
Fantástico. Somos muy buenos. Tú eres muy bueno porque yo he hecho un inglés. Me ha